It's been 6 years since a cell phone, popcorn, and a pistol permanently changed the lives of a small family in suburban Tampa, Florida. Chad Olson loved spending time with his wife, Nicole, and their 22-month-old baby girl, Alexis. Friends and family say Olson was a genuine, funny, go-getter type of guy. On January 13th, 2014, Chad and Nicole Olson were sitting in a theater waiting for a movie to start. And as the previews were rolling, Chad was on his phone, texting their babysitter to check on baby Alexis. This security video shows the man sitting behind them, Curtis Reeves, objecting to Chad using his phone, and the two start arguing. Then Reeves went to complain to the management. Here's Nicole Olson recalling Reeves' demeanor that night.
I see you've put your phone away now that I went to get management. I remember feeling this should have been over. He's got what he wanted. Why is he still doing the, ha, you did what I told you, I won? That's kind of how it felt to me.
Witnesses told police that the argument continued when Reeves returned to his seat. In a recorded audio police interview, Nicole describes what happened next.
My husband said, dude, what's your problem? You know, I wasn't making any noise. The movie hasn't even started, and that's all I remember.
Then the argument went from loud to lethal. Reeves, a retired Tampa police captain, claims he feared for his life after Nicole's husband threw a bag of popcorn at him. In his police interview, Reeves said Olson stood up and hit him in the face with an unknown object. Let's watch that again, slowed down. You can see what looks like Olson's arm make a very quick motion toward Reeves. Here's how Reeves remembers the incident.
Get out of my face. I'm leaning all the way back in my chair as far as I can to get away from him, and suddenly he's virtually on top of me. And I think I'm saying either no, 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 or whoa, whoa, whoa. Suddenly my head was to the right, so he hit me with something.
And that's when Reeves pulled his pistol from his pocket and fired one shot at Olson.
I did not see him pull it out, and I did not see him shoot it. I just saw the spark and heard the noise.
43-year-old Chad Olson was taken to the hospital where he later died. Curtis Reeves was charged with second-degree murder. He says he shot in self-defense. At a hearing in 2017, Reeves' attorney tried to prove that this was a stand-your-ground case. The controversial Florida law allows people to use deadly force when they fear death or personal bodily harm.
A 6'4" individual standing, trying to come over that chair is terrifying.
But the judge ruled that the stand-your-ground defense does not apply in this case.
If I had it to do over again, it would never have happened.
It's too late for regrets. Now the 76-year-old Curtis Reeves is set to go on trial in October for second-degree murder.
This is one that's been brewing for many, many years. Let's bring Julie Grant in. And Julie, looking at that video, I don't really see the victim at all. Do we see his arm or the popcorn, but we don't see his body in the same row, right? They're in separate rows.
Right. It's really tough to see with that video, isn't it? Right. I mean, Vinny, we've been studying this at Court TV, and here's another look again. It is really, really tough to see. And we know there are witnesses to this, of course. I mean, we know his wife, who's right next to him, and then Curtis Reeves, of course. I think we can probably expect testimony from him, especially in the fact that he testified previously in that immunity hearing where they wanted to try to make him immune from prosecution with the stand your ground defense. So this is really a tough one. The one piece of evidence that could be most telling for the jury is difficult to see.
Yeah, let's take a listen to Reeves, who testified previously in another hearing, talking about complaining and really initiating everything here.
Contact him. He wasn't bothering you.
I believe I had made that fairly clear, didn't I? Did you not understand that I was trying to settle down? If there was any hurt feelings, I was trying to resolve them or end them so that he could enjoy his movie and I could enjoy mine.
That's an interesting back and forth, right? Because that's where I guess he's being cross-examined by the prosecutor, and he's remaining calm. He's a former police officer here, so I'm sure he's probably testified many times before.
Yes, he most definitely has experience in law enforcement. He left at the rank of captain, Vinny. So this is someone who served in a very noble profession for a very long, long time. And now he's finding himself on the other side of the law. And that calm nature you just pointed out there, I mean, that's his demeanor. So perhaps this is what we can expect to see at trial. But the one thing that's I think somewhat favorable for the other side, just looking at this analytically, is that Curtis Reeves is initiating that contact. He keeps initiating it and initiating it and initiating it. And we know it seems like the defense is going to be self-defense, stand your ground. So to me, that sort of weakens the self-defense argument if you're the one provoking, going after the other individual when we're talking about cell phone use in a theater, Vinny.
You know, he reminds me to a certain extent of Michael Draka, who's also from the Tampa
Yes.
area. Remember that case?
Sure
Michael
do.
Draka was kind of like the self-appointed handicap parking spot police. Well,
Yep.
it seems like Curtis Reeves has a little bit of a history about complaining about people with, I guess, texting and doing things in movie theaters. Let's take a listen.
On December 28th of 2013, she was at the Cobb movie theater when she was confronted by the defendant for texting. She felt very uncomfortable about it and indicated that he was glaring at her the entire time throughout the movie, and afterwards she felt very uncomfortable with this.
And that is a third party,
I'm
a
sorry?
third party who may have responded to news.
Yes, Judge. And he also followed her to the bathroom when she had gotten up to go to the restroom and made her feel very uncomfortable.
So there, Julie, it's just like the Draka case where there's someone else who was confronted by the shooter about whatever their issue was. I guess his issue was texting in the theater.
Exactly. Great comparison, Vinny. And yes, and to give our viewers a little bit more context, this was a bond hearing. And so that was the prosecutor's voice who you heard telling the judge that a woman reported a very similar incident with Reeves, making her feel very uncomfortable for texting in the movie theater. And this allegedly happened about a month before the shooting took place. But we think that once this story hit the news, this woman saw this, recognized him, and said, oh, wait a second. This happened to me too, and alerted prosecutors. So yes, you're right. Is there a pattern here? And might prosecutors even attempt to establish a pattern here? Maybe the evidence will be so strong. We know that came in the Draka case, as you mentioned, Vinny, with victim Marquise McLaughlin, and how Michael Draka was policing that parking spot. Wasn't the first time on that fateful day, but they brought that evidence in. So who knows if that may become the prosecutor's MO in this one.
And the bottom line, as you reported, there was a stand your ground immunity hearing. The defense lost, but that doesn't really impact the trial necessarily in what they can present as a defense here.
You are exactly right. And this can be a little bit confusing because all the headlines we're reading, stand your ground defense is out, it's out, it's out. No, what's out is that Curtis Reeves is immune from prosecution. That's what's out, right? And so as you just said, Vinny, they had that hearing and the judge said, no, you're going to be prosecuted for this. Case goes. You can choose to have it heard by a jury or by the judge. And his attorneys most certainly can present that defense before the jury. Most certainly they can argue this is self-defense, present evidence to that defense if they wish, and try to argue stand your ground before the jury to try to get an acquittal here, Vinny.
And it's a case, again, goes back to 2014, been fully litigated, ready for trial. Julie Grant, thank you so much.
Thank you, Vinny.